Hello and welcome to Verdictum. I'm Sheetal June, and in today's episode we will talk about bail principles and norms that were highlighted by courts during this week. Bail is the rule and jail is the exception. The Supreme Court has reaffirmed that this principle applies even in the PMLA cases. A division bench of Justice B.R. Gavai and Justice K.V. Vishwanathan relied on the judgment delivered in recent Manish Sisodia bail matter to stress that the liberty of individual is always the rule and deprivation by procedure established by law the exception. Twin test as specified in section 45 of the PMLA does not take away this principle. The court made these observations granting bail to Prem Prakash, allegedly an aide of Jharkhand Chief Minister Hemant Soren in a money laundering case. The bench referred to section 45 of the PMLA that mentions a twin condition for bail. There should be prima facie satisfaction that the accused has not committed the offence and he is not likely to commit any offence while on bail. It pointed out that these are mere conditions to be met and serves no hindrance in applying the general principle of bail. The Supreme Court also took exception to interpretation of the proviso to section 45 of the PMLA and granted bail to BRS leader K. Kavitha in both the ED and CBI cases linked to the alleged Delhi liquor policy scam. A division bench of Justice B.R. Gavai and Justice K.V. Vishwanathan observed that courts, while deciding such matters, should exercise discretion judicially. A woman being well-educated or sophisticated or a member of parliament or member of the legislative council does not disentitle her from the benefit of the proviso to section 45 of the PMLA Act. On Delhi High Court's interpretation, the court remarked that if it is allowed to become law, these perverse observations would mean no educated woman can get bail. The Bombay High Court has directed the subordinate courts to decide anticipatory bail expeditiously as liberty of citizens is on line in these cases. A single-judge bench of Justice Sandeep Marne said that when the question of liberty of a citizen is involved, it is necessary that lower courts take up and decide applications seeking anticipatory bail either finally or at least for grant of interim protection in an expeditious manner. He added that if lower courts do not decide such matters, then it unnecessarily burdens the high courts. The court was expressing displeasure with the lower court at Kalyan in Thane district for not deciding expeditiously the pre-arrest bail of Vaman Mahatre, a local leader of the Eknath Shinde-led Shiv Sena. Mahatre is accused of making derogatory remarks against a woman journalist during the last week's protest in Badlapur over the sexual abuse of 2 kindergarten girls. The Uttarakhand High Court has granted default bail to 50 people accused in connection with the Haldwani violence in February on the ground that no charge sheet was filed even after 90 days of the incident. A division bench of Justice Manoj Kumar Tiwari and Justice Pankaj Purohit, overturning the lower court's previous decision to grant the police additional time to file the charge sheet, called the investigation sluggish and probing officers careless. Violence had erupted in Nainital after the administration conducted a drive during which a mosque and a madrasa were demolished in Banbhulpura. Thank you for watching the video. Hope it was helpful. For more such informative content, subscribe to our channel and download the Verdictum app on iOS and Android devices.